Anna, that is so good. Kelly, I'm going to come down there and fight your inspectors. I swear one of these days I'm going to come down there. I'm going to fight them. It's bull. You'll be fine, though. You will be fine. Go, 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 go. Hi, guys. It's Kathy. I hope you're doing well. So, some of us have never left. We just stayed from the last stream and we're still here. Thank you to all that came out last night. 7 hours ago. Appreciate it. And here we're going to do it again. We're going to start with pro se, because that's a great idea. My pro se is gone. Here it is.
Boy, I ain't killed nobody.
I ain't killing nobody. I'm gonna Kelly's inspectors.
You said murder. You said murder arrangement.
That's what that paper said. I don't know. I was just going off what my paper said.
I know me and the officer got the fighting in ISP. I know they ain't killed no motherfucker. Ain't no motherfucker in lockup. I just came from lockup at ISP. And I know you can't possibly have the battery, try to charge me no battery on staff. He assaulted me with a handcuff, and he used them as if they were some brass knuckles and hit me in the mouth with them. You can't charge me with battery on staff. I don't do shit like that. He battered me. What time is it? 12:30 yet?
It's 11:30.
Oh yeah, it's that time. It's 20. Yeah, it's 11:26. I thought you said murder out of hell car. Wow, I was happy.
He is already incarcerated until 2051. So Bren, absolutely. He's my new man. I'm completely okay with that. You stay there. I'll stay here.
Maybe Taylor.
Every once in a while, I'll come and see you and bring you some commissary, put some money on your books.
What the victim at? You see, what the motherfucker ever did say?
Where the victim at? Where the victim at? It's for murder, sir. Murder. The victim is buried.
I'm 100 pounds. The officer I got to fighting with, this motherfucker was like 6'4". She about 300 pounds. African dude. I'm an American African. You hear me? I'm an Irish African. You see, he from Africa. He a real African. They have no idea the evidence that I got. This is in retaliation because I filed a lawsuit already against this. I'm upstairs working on it right now. We filed to the federal court. I gotta go back and look that up. That's like that's retaliation or something. And officer, by law, it's Indiana law. If you create your own injury, I'm not responsible for doing it to you. You hear me? That's Indiana law. So I don't know why this prosecutor up over here at the court over here wasting his time. I ain't pleading guilty to a damn thing. You gotta take me to trial. Got to. I ain't pleading to no motherfucking battery. This got to be the battery because we got to fight in that ISP. Officer tried to bully me. I mean, that's what I'm here. That's what I'm here for. They already punished me. They gave me SIG time. You know what I'm saying?
They muted him, so I cut it instead of watching this for another 7 minutes.
We're just getting ready to do it without you.
Yeah. Apologies. I didn't know there was no one down here today.
That's all right. It's just one case. Easy peasy.
Got it. Judge, what's the name of the defendant?
Jonathan McPherson, McPherson. Do you need a cause number?
I don't think so.
You need a copy of the charging information.
I have it, Judge.
Okay.
Thank you.
All right. Okay. Can you hear me, sir?
Yes, sir. I can hear you. How you doing today, Judge?
I'm doing well. How are you doing, sir?
I'm doing okay.
All right. This is State of Indiana versus Jonathan McPherson, cause number 46D02-2603F1301. Show Mr. McPherson appears by.
It's Terry. Terry, just main girl is Terry with an I. And then we have Terry with a Y.
By video. Where are you currently housed, sir?
I'm at Westville Correctional Facility, WCU,
No, you're not.
lockup unit.
Okay, thank you, sir. This is an initial hearing on a case that's been filed against you. I'm going to tell you what your rights are, and then the state of Indiana is going to tell you what the charges are and what the possible penalties can be, and then you and I are going to have a conversation about getting you a lawyer, okay?
Yes, sir.
All right, you have the right to the assistance of a lawyer. If you intend to hire a lawyer, you must do so within 20 days after this hearing because there are deadlines for filing motions and raising defenses. If these legal deadlines are missed, the issues and defenses that could have been raised will be waived or given up. If you want a lawyer and you are unable to afford a lawyer, the court will appoint a lawyer to represent you at no cost if after this hearing you're determined to be financially unable to hire a lawyer. Sir, have you received a copy of that charging information yet?
No, sir.
We're going to make sure we get you a copy of that. We'll send it to you, okay?
Yes, sir.
All right. If you plead guilty, you waive or give up all of these rights I've advised you of, and you admit the truth of the facts contained in the charge against you. This is your initial hearing. We are entering a formal plea of not guilty on your behalf. Do you have any questions about the rights that I have advised you of today?
No, sir, but I would like to go pro se, and I would like a fast and speedy jury trial.
We'll get to that in just a second, okay?
Yes, sir.
All right. Please pay attention. The state of Indiana is going to read you what the charging information says, and then they're going to tell you what the possible penalties can be.
Yes, sir.
Mr. McPherson, the charging information includes 3 counts and reads as follows. On October 8th of 2025 in LaPorte County, state of Indiana, Jonathan McPherson, while acting with the intent to commit the crime of murder, did strike Officer Prince Boating with a deadly weapon in the head, which conduct constituted a substantial step toward the crime of murder, which is to knowingly kill another human being. This is a level 1 felony. Level 1 felonies are punishable between 20 and 40 years in the Indiana Department of Corrections with an advisory sentence of 30 years and a fine of up to $10,000. For count 2, on or about October 8th of 2025 in LaPorte County, state of Indiana, Jonathan McPherson did knowingly or intentionally inflict injury on a person that creates a substantial risk of death or causes serious permanent disfigurement, specifically by striking Officer Prince Boating with a deadly weapon in the head. This is a level 3 felony, punishable between 3 and 16 years in the Indiana Department of Corrections, with an advisory sentence of 9 years and a fine of up to $10,000. And for the final count, on October 8th, 2025, in LaPorte County, state of Indiana, Jonathan McPherson, while incarcerated in a penal facility, specifically the Indiana State Prison, did knowingly or intentionally possess a device that is intended to be used in a manner that is readily capable of causing bodily injury, specifically sock with a lock contained inside of it, and the device is a deadly weapon. This is a level 4 felony punishable between 2 and 12 years with an advisory sentence of 6 years and a fine of up to $10,000.
Sir, do you understand what the charges and allegations are against you?
Yes, sir, I do.
And do you understand what the possible penalties can be?
Yes, sir.
All right, so what is your current out date?
2051.
Okay. You are asking to have a fast and speedy trial, and you're asking to represent yourself. Let me ask you this. Did you want to have a consultation with an attorney before you do that? Or do you want to represent yourself from the get-go?
I would like to represent myself from the get-go.
All right. So let me ask, I got to go through some things with you and ask you some questions just to make sure that you're able to represent yourself and that you and I are both comfortable with that. Are you under the influence of any drugs or alcohol as we talk today?
No, sir.
Are you taking any medications that would affect your ability to understand the proceedings today?
No, sir.
All right. You've indicated you want to represent yourself at.
Do you guys remember I had another jail fight where a guard got injured, and we watched the body cam and we watched the prison cams. He went in because he was mad about it. He got written up. He got a ticket for something stupid. It doesn't matter. I don't remember what it was. And I guess the captain or the leader of the guards, this guy went in to complain about the ticket. Remember, the leader of the guards had snacky snacks right there in his office. This guy is not him. This is a completely different state. But don't they look similar? They look really, really, really similar.
Trial, and you have that right to do that. Before we make a final decision on that, I want you to understand some things that you'll be giving up. You may have any number of defenses that can be raised and can be pursued, which an attorney would be trained to know. Should you be convicted of the offenses that are listed herein, you know you're facing a lot of time in prison. Do you understand that?
Yeah, Judge. Yes, sir.
Okay. And there are factors that we can consider that would allow me to increase that sentence above the advisory sentence are vast, and attorney would be trained in how to navigate those issues. Do you understand that?
Yes, sir.
They also have skills that they've developed, including how to investigate your case. You're currently incarcerated. That makes it more difficult for you to investigate your case. They are outside and have the ability to track witnesses down, talk to witnesses, and find favorable evidence on your behalf, which would make things easier for you. Do you understand that?
Yes, sir.
They're also trained and able to explain charges and any lesser included offenses that could have been brought up. They can gather written and other documentary evidence that could be used. They can prepare and file motions in court for things and try to keep unfavorable information about you as being entered into evidence. They are trained to examine and cross-examine witnesses as well as to present evidence, recognize and object to unfavorable evidence, and they can also present favorable information and attack unfavorable information when it would come time for sentencing. In jury trials, there are set rules that are in place, and they are trained and have the knowledge and skill to be able to follow those rules. You're going to be held to those same rules. Do you understand that?
Yes, sir.
You're not going to get a break because you're representing yourself. You're going to have to follow all the same evidentiary rules that an attorney would follow.
Yes, sir.
Okay. Do you also understand, in addition to not getting any special treatment, the state of Indiana is going to have an attorney representing them, and they're going to be trained in their presentation of the case against you?
Yes, sir, Judge.
You understand that if you represent yourself and the case doesn't turn out the way you want, you're not going to be able to complain that you did not have an effective attorney, so that that one complaint or that one issue on post-conviction is taken away from you because you have agreed to represent yourself. Do you understand that?
Yes,
You're
sir.
not going to be able to go back and say, well, if I'd have had an attorney, things would be different. So now I want to appeal or I want some post-conviction relief. Do you understand what I'm saying?
I really don't, but
So there's certain things you can say and appeal after trial. Not having an attorney is not going to be one of those because you agreed to represent yourself. Do you understand that?
well, how about I ask for an attorney?
You can't come back and say, what's the do-over because I didn't get an attorney.
I would request an attorney, Judge.
You would like one?
Yes, sir.
Okay. Then what we're going to do is set this over. What do we have for?
It probably really wouldn't have mattered if he, I don't know, if he got an attorney or didn't get an attorney or went pro se, because he's in jail till 2051 now as it is. So, but no, now he just wants an attorney. Smart choice,
April
sir.
24th at 9 a.m. for status. You'll be here in court with your attorney. So at any time, if you decide, hey, I think I want to represent myself, you're going to have this conversation again, and then
Premature
we'll let you do that.
for
But
post-conviction
I really
release
prefer
right
you
now.
talk to an attorney before you do that. See if you get a good vibe with your attorney and things go well. We have a very experienced attorney that represent people in this court. They're not brand new. They've been doing it for 20 plus years, and they're pretty good at what they do, okay?
Yes, sir.
All right. So we're going to see you on April 24th at 9 a.m. We're going to transport you here. You'll get a chance to meet and talk with your attorney. And then you and I and he and the state will talk about setting this matter for trial. Okay?
Yes, sir.
You have any other questions?
No, sir.
All right. Right now, you currently have a bond set at the amount of $250,000 cash. Is there anything in your case right now that you have against you that you think might get you released earlier? Do you have any appeals or post-conviction issues going on that you could be released prior to the 2050 date that you said?
No, sir.
Okay. Then I will see you here in just about a month, all right?
Okay, thank you very much, sir.
Do you have any other questions?
No, sir.
All right. We'll see you then. Thank you.
Thank you.
Bye, sir. Maybe I'll make some Easter baskets this year. Maybe. I haven't in a couple years. So Easter used to be a big deal in our family, and like we would have these humongous Easter egg hunts for the kids, for my kids, my sister's kids, everything like that, and there were huge prizes involved. It was just a big deal. It was a great big food day. It was a great big everything day. We actually went to church, and then I used to go to church twice a week, every week. So Easter was a big deal, but we haven't. That's all over now. It's completely over now. So we don't celebrate with the family anymore. That's for darn sure. So maybe I should make an Easter basket for my kids this year. That would blow them away. They'll get a chocolate bunny. Of course you got 2 baby ducks. Of course you got 2 free baby ducks. Mel, do you want some cats? There's one right here. There's a cat right here you can have. Spooter. I'm going to change Spooter's name because she doesn't listen to her name anyway. So I can't stand it anymore. I can't stand calling her that name. I don't even know what it means. Is that in a movie? Like, is it possible that's from Cars? That cartoon? I didn't see Cars, so I don't know. But I'm changing this cat's name to something else. Methany is taken. There's already a meth downstairs, so I can't call her Methany. Darn it. All right. Name suggestions for the ducks. How about Spooter? Steven! We used to, so Pennsylvania get a lot of snow. There were times when we used to hide beers little mini liquor bottles, things like that, out in the backyard. Not bury them or anything, just place them around before the snow. And then when it was like 14 inches deep, we had to go find the liquor. When the snow melted, we always found the rest. That was fun. That was a good time. It just was. Especially when we had a big fire going. I have 2 scars on my leg that have been there since I was 5. From when it snows, you make you go around and you make these trails in the snow. All right? And then you play tag. And you have to stay in the trail that you made. It's very slippery because, it's snow. So it's very slippery. So I had on my great big snowsuit. Those great big thick snowsuits. And I'm out there running away from my sisters, and I slid. Fell right into a rose bush, and it hit a so like you could see the blood. You could see it coming out. My dad put a Band-Aid on it. There were 2 cuts. He put one Band-Aid on it and then sent me to bed. And my mom came home, and I was just sitting in a big pool. And she had to take me to the doctor. But yeah, I like them. I think they're pretty. I don't care what anybody says. They're right on the knee, but they're on the side. I don't care. They've been there since I was 5. All right. This next clip, I'm not going to say half. I'm going to say way less than half are going to find this judge enthralling. And then people are going to find him boring. He's about the law. He knows the law. I've seen this judge work serious, the real boring tax cases or probate cases. I've seen this judge handle the most crazy divorces. He's one of my favorite judges ever to watch, and I love when I play him. And this is what I found in the 6 hours we had off in between this stream and last, so you're going to watch this. But if you're here for crazy court, that's over. This does get a little crazy, but it's a build-up. It's a slow burn, and then it gets there a couple times. Judge Frost from Wisconsin. Oh, that's the other judge from Wisconsin. Here we go.
Yep.
I love Judge Frost. I just do. I'm going to be busy, guys. Let me watch in court.
Good morning. Can each of you see and hear me okay today?
Good morning, yes.
Yes.
All right, good. Let's go on the record in your case. Give me 1 second. This is case number 2016 FA 1132, in re the marriage of Crystal Yelk and Brian Yelk. For the appearances today, I have each of the parties appearing separately on Zoom video, each representing yourselves today, and we are all on Zoom. I've confirmed we can see and hear each other, and we're live streaming since we're on Zoom for you today. We are here on there was a motion to modify placement filed a while ago by Mr. Yelk, and then it has come to me from the commissioner on a motion to dismiss, and that's what we're here to talk about today. So I'm just going to jump right into it with some questions. Ms. Yelk, can you clarify for me, how far is your new home from your prior home?
It is around 20 minutes, 15 to 20 minutes off the highway.
Okay. And how long was your trip from your old house to the school?
5 minutes.
And now it is 20 minutes?
Yeah, between 15 and 20 minutes.
Okay. Okay. And has 15 and 20 minutes. And you've made plans for how to do pickups and drop-offs?
Yes, we've actually been doing it for this whole school year. I take him and drop him off and pick him up to school and off school. So it hasn't had any issues with it. He's not been late. He's not had any absences. His grades are great. Nothing's changed for him.
Mr. Yelk, your motion only mentions the move from where you live to a different community. In and of itself, unless it's a...
Mel, I got an idea. Can you name one Kathy and one Thor? There's Kathy and Thor out there.
substantial distance where it makes a substantial change in circumstances affecting the best interests of the child. Just because somebody moves in and of itself isn't a basis to change placement. I'm not understanding if your motion didn't allege anything else. Is there something else you think has changed?
Well, basically, I filed this because she moved 22 minutes away, and she used to live 5 blocks away, which was about 5 minutes. And when she lived 5 blocks away, he was late for school like 17 times. Tardy, didn't go to school because he felt sick and stuff. His grades were slipping, and he wasn't taking his medicine for ADHD. And all those papers I filed with the court, and
ADHD. He had trouble spelling that, guys, but he got through it. I'll give him a 9 out of 10.
if she wasn't able to get him to school on time and get him his medicine and all that stuff when she lived 5 blocks away, I don't see her doing that 22 minutes away. Now, yes, she is correct that there hasn't been any problems with getting to school on time in the last 3 months, but I do also have things for the school that he missed his medicine already again.
Okay, and you said that you filed them all with the court. When did you file those?
When I filed all the paperwork for this motion, I don't know, 5 months ago, all the evidence.
So she moved 20 minutes away from the house she used to live at, and he filed a motion because he's mad. It is like around the corner. It's like right down the road. Oh, I like
You
Quexy
filed a
Chan.
motion to modify child support and placement on June 27th. It didn't have anything attached to it. And I'm not seeing anything really close to it. Looks like maybe around August you had a hearing with the commissioner. Are you thinking that you filed it around then?
Possibly. He looked at all, Schulenberg had looked at it last time we were in court. And he said that you were able to see all that.
Okay.
I had a cat named Judge Fleischer, and you should have a duck named Judge Fleischer. Edward and Jacob. I did, Eileen. We found him a great home, so I don't have him anymore. But his name was Judge Fleischer.
Okay. As drafted, the motion that you filed does not state anything that I would consider a basis to proceed because it doesn't state anything that would be a substantial change in circumstances. A 20-minute move is not much at all, in all honesty. So you would have to show facts beyond just the fact of moving to show there's a reason to modify. The motion as drafted doesn't mention anything about tardies, about missing medicine, about any other issues at Miss Yelk's house. If you have specifics about things like that, you'll need to file a new motion and walk through in detail what those reasons are that have to do with what's actually going on in the house as opposed to the move. And then me or the commissioner could better assess if you've properly filed a motion at that point warranting reappointment of a guardian ad litem or referral for a study. But unless you establish through the motion some facts that show there is a good reason to reevaluate all of this, just saying that somebody moved about 20 minutes away in and of itself is not enough. So I am going to dismiss.
That was all filed in that. It brought up at requesting.
Well, sir, I'm telling you it wasn't. I pulled up the motion. There was nothing attached to it. That 2 months later you filed some paperwork that was nowhere mentioned in your motion is different.
Hi, Patty. Welcome. Thank you.
So you're trying to add to your motion by submitting a bunch of other things without putting together a narrative to explain why you think a change is in the best interest of your son. And from what you're telling me,
There you go, Mel. Peppermint Patty.
it's that regardless of where Miss Yelk is living, that she's not doing X, Y, and Z, and that it's harming your son, either his school or his treatment for his ADHD or something similar.
Oh, Nan, where were you last night? Where were you last night? Nan, I needed you. Nan, guess what? Last night, Bren said I should interview one of the people. Right. And I said, no, we never communicate with these people. We never talk to these people. We watch just like the Telemascus. And you would have understood. We are just like the Telemascus. You would have understood, but no one else did. No one else reads Ann Rice.
You need to put that into a written statement, file it as with your motion. If you want to attach proof of that, you could, and then we could go from there. But you just have not put any of that out there in writing as part of a motion. So we would be deciding it based on something completely different than what you put in writing.
Okay.
Okay. Do you have any questions about what you would need to do if you choose to file another motion?
No, I'll take care of it.
Okay. If you do that, flag in a letter to me or the commissioner that you're filing it essentially to correct the issues I addressed and ask to have mediation waived. I don't want it to start from scratch again and send you back to FCS because that's just going to waste both of your time if you already gave it a good faith effort, which I understand you did.
Okay, and like it said, because when I filed all this stuff, the first step was to go to mediation, and we went through all that.
Exactly. So if you file a new one in the very near future over these issues, I would waive that. And if you flag it to my attention, I would waive that. You could also mention, and I'll have my clerk put in the notes on the CCAP entry for today, that I've said if you file an amended motion in the next, I'm going to say in the next 2 months, that I would waive you having to go back to mediation.
Okay, thank you.
Okay. Miss Yelk, any questions on that?
No, sounds good. Thank you.
All right. And I do have now those updated records I'd asked for from child support and from each of you. So I'm just going to run my numbers and get you a updated order clarifying exactly the overpayments and underpayments of child support. So I should get that out to you relatively soon.
All right, thank you.
Thank you.
Any other issues we can address today while I've got you both?
No, that's it.
I have none. Thank you.
Okay. All right. Well, I hope you both have a good rest of your day.
You too. Thanks for your time.
Thank you. Good morning, Mr. Flieger. Can you see and hear me okay? All right, good.
Yes.
Attorney Bach Van Horn, how about you?
Yes, Your Honor.
And Ms. Cox, are you there? Ms. Cox, are you able to unmute and let me know if you can see and hear us?
I can see you. Can you hear me?
I sure can, yes. Can you hear me?
I can. Thank you.
All right, good. Mr. Flieger, that's a really interesting background you've got there. That's kind of cool.
Thank you.
All right, let me call the case. This is 2017 FA 205.
He's very, very, very structured. He's very law. This guy knows all the laws.
3. In re the marriage of Mia Cox and Michael Flieger. For the appearances today, Attorney Bach Van Horn, please get us started.
Thank you, Your Honor. Mia Cox appears by Zoom video and with her attorney, Elizabeth Bach Van Horn, also by Zoom video. Mr. Flieger appears by Zoom video and pro se.
Thank you, and I have confirmed.
Brent, I was just this close to getting canceled. I was this close to losing everything. To saying something so bad.
We can all see and hear each other on Zoom today. But Ms. Cox does not have video on, which is totally fine, but I've confirmed she can see all of us and I can see everyone else. And we're live streaming since we're doing this by Zoom for everyone today. We are here on 2 different motions by Mr. Flieger to stay some of my orders to do with paying back towards some balances. And Mr. Flieger, I just want to be clear, is it only the attorney fee part that you're asking to stay, or both that and the arrears?
Just the attorney's fees, Your Honor.
Okay, that was my understanding as well. So I think there's probably 2 different standards that apply to your requests. When it's a request for a stay pending appeal, that's a very specific standard. I don't know.
If you listen to the legalese that's going on here, this guy's a jerk.
If you've reviewed it at all, but that kind of the key case that they refer to as the Gudenschwager case and the Gudenschwager standards. And there is some case law that further explains how those factors don't neatly apply to a money judgment, that there's a little different consideration with a money judgment versus other types of orders that go up on appeal. So for that motion, if you're prepared, I would like you to address those factors. If you've not reviewed that prior to today, I could probably pull up that case and just go through the factors and ask you about each of them. Is that something you've already looked into?
And not under that name, Your Honor. I've looked at the statute and to the best of my ability tried to interpret what the factors could be. And if would you like me to give it a try and let's see how I do here, or do you want to? How do you want to proceed?
Yeah, let's do it.
Okay.
And I think what I'd like to do is, well, on that motion, I don't think I need testimony. On your other one, where you're trying to show your finances and ask for a modification, really, or honestly, it is. It's just a modification.
He's so kind, though. He's so smart.
Not really a stay. There, I think I would need testimony. So if you want to tackle it all at once, I'll put you under oath and you can address your financials and argue to me about the appeal part and why I should stay at pending appeal. If you'd prefer that I address one at a time, which might make sense in that if I would give a stay pending appeal, I don't need to get into the other motion because it's moot at that point. Now that I've talked through it, I think that makes more sense so that we can figure out if we even need to address the modification. So yeah, go ahead. Give me your argument on the stay pending appeal.
Okay. If I'm looking in this direction, it's just because I have another monitor and it's some documents are electronic.
You're totally fine.
Okay. I didn't look at the Gudenschwager as case law, and so I'm prepared to speak to that. I did file an appeal of the motion of contempt, or I'm sorry, for the finding of contempt and the resulting fees. I wasn't sure that it would be proper to speak to that in this setting, or whether because those would be arguments that I would make through a brief to the appellate court, and then I guess oral arguments on both sides with a responding brief by Ms. Cox, an attorney. Am I supposed to indicate to you what I'm appealing and why? And that would be the reason for you to...
For a stay pending appeal?
Yeah.
Kind of. So you do have to get into that. Let me read you a little bit with these factors so you can understand, because it is part and parcel of what I have to think about.
You attack Judge Frost, you attack me. I love Judge Frost. He's so good.
So just give me one moment while I'm getting to the right spot of a case.
Do you guys remember when he had the case with the presidential candidate who drove a lawnmower? It was a divorce. Oh, it was super crazy. He moved away, moved in with his father or something like that, and the poor wife, had to deal with all this crazy stuff. And the judge was on point. Like, this guy kept going off into left field. He had all this farming equipment that they were trying to sort through for the divorce. And do you remember that? It was really good. It was one of my favorites from Judge Frost.
So I'm looking, there's 4 factors under Gudenschwager. I'm looking at another case that explains how they're a little different with a money judgment. So I'll have to read you 2 different parts. This is the Scullion, Scullion versus Wisconsin Power and Light Company case. It's a 2000 WI App 120. And paragraph 5, the Court of Appeals talks about how they talk about their own prior order where they cited Gudenschwager, GUDENSCHWAGER 191 with second at page 440. And there, a stay pending appeal is appropriate where the moving party, 1, makes a strong showing that it is likely to succeed on the merits of the appeal. 2, shows that unless a stay is granted, it will suffer irreparable injury. 3, shows that no substantial harm will come to other interested parties. And 4, shows that a stay will do no harm to the public interest. And then in those factors, it's explained, are interrelated, and I have to balance them together. In other words, in one case, one might be really important and outweigh the others. In another case, a different one could be really important, and I have to look at and weigh them on the whole. And I'm going to try to find where it talks about how it's a little different with money judgments. So it goes on at paragraph 18. It explains a little bit more that including with the money judgment, the movement need not always establish a high probability of success on appeal, but it must be more than a mere possibility. And I have to consider the standards on appeal, so you might want to address those. It then talks about, I have to consider the need to ensure the collectability of the judgment and the accumulated interest if the appellant does not succeed on appeal. And it also talks about I can consider whether or not you're going to file an undertaking or otherwise provide security in an amount that I decide is sufficient, or prove to me that whether or not I require an undertaking or security, that there's no risk that you will not be able to pay the full judgment plus accumulated interest and costs. And then they talk about I have to consider the interests of the appellant in securing the fruits of the appeal if it is ultimately successful. In other words, Ms. Cox's ability to get paid and her interest in being paid. But also, it talks about how you don't have to, the appellant need not show that the inability to recover such money as a successful appellant will cause it irreparable harm. Rather, the underlying principle here is that the right to appeal a money judgment is not a meaningful one if the money must be paid pending appeal and cannot later be recovered. In other words, if you would win on appeal and not owe money, would you be able to get it back from Ms. Cox? And then there's a fourth factor that may be relevant in some cases, the harm to the respondent that may result if the judgment is not paid until the completion of an unsuccessful appeal. And there, an undertaking or security or other proof of financial ability.
Now, you've got to give props to this man. He listened to all of that. And he understands the 4 points that he has to get through right now to give back to the judge, which is amazing for pro ses because they just only want to put their evidence forward and they don't care about anything else. This man is actually going to hit every single one of those 4 points and prove he's a jerk.
Is often enough, but there can also be an argument that delay in being paid on a judgment could cause harm that cannot be remedied by collecting it at a later date. And in evaluating this harm, paragraph 22 says the circuit court should consider the substantiality of the harm asserted, the likelihood of its occurrence, the adequacy of the proof provided, and whether it truly is a harm that cannot be remedied by the later collection of the judgment plus interest. So an example I could think of there would be if somebody wasn't going to be able to pay for their house because of a payment and they were going to lose it, just getting paid later doesn't really help if you've lost your house in the next couple of years because of it. So those are kind of the broad scope, a quick summary of a case I was able to pull up right away of what you need to address. So were you able to get some notes down or do you want me to kind of ask one at a time about the factors?
Yes, I did write some notes, and those were essentially what I had found as well in the research I was able to do. So but it's really helpful to hear you talk more specifically about them. Can we start at the bottom of the list, perhaps, and just address whether or not there's a harm to the public here? And it doesn't seem that there's any harm to the public regarding the payment schedule between Ms. Cox and myself. And I can't imagine what argument could be made that the public would be harmed if my payments were delayed. Should I just keep going?
Please do.
Okay. In terms of irreparable injury or harm to Ms. Cox, I don't believe that this would cause her any harm. It seems that she has very low mortgage payments and that her debts are already being covered without these payments they've been made, or they just haven't been cashed. And so Ms. Cox did not cash the February check that I provided, and the other one was provided yesterday. And so it doesn't seem that there's any urgency in getting these things cashed. And there was and I'll just mention not the details of it, and hopefully that's proper. There was a proposal to delay that was offered, and so I think that there's a case to be some evidence that Mia could wait for these payments to commence at a later date when it's more financially certain that I can make the payments. In terms of the injury to me or the harm to me, obviously, my financial disclosure shows that I'm pretty much underwater. I have been working with the credit card companies to
I didn't know,
establish.
but I just looked it up, and he has spinal muscular atrophy, so he's in a wheelchair. I've never even noticed the wheelchair. I see Judge Frost going to, like the Supreme Court as a judge someday or something. He is so good at his job. Donald, thank you so much. Thank you. Yeah, but I've never noticed the wheelchair at all, not once. But remember we had that the lawyer in Washington, and we never saw him in a courtroom. We always saw him in the jail. Was it Washington? I really think it was Washington. And he was blind. And it took us like a year and a half to figure out it was blind. We just accidentally saw him whip out his cane once, unfold his cane after his court one day, and feel his way to get up. And that was crazy. I ignore you. I'm ignoring you for 7 streams now. 7. That's how many books it'll take to get over your statement.
A settlement for less than the principal of those balances, but that does increase the monthly payment schedule for those. In addition, there's some credit cards which I'm delinquent on. A lot of these expenses.
Just drink 2 bottles instead of 1. It tastes delicious.
This arise from a couple of different things, but one would be attorney fees that I incurred over the last year and a half to pay Mr. Mink for a consultative role. I'm no longer working with him, so I'm on my own now. And so budgeting out, I'm still paying child support, arrears every month, and those have been paid 3 times since January. And spousal support as well. And so, of course, my monthly income, disposable income, has reduced as a result of the increase in payments plus these additional payments. So the other question I think that is part of this is just trying to be responsible and making sure that I can pay, is an uncertainty as to how long child support will actually continue. It would have normally been the case that child support would end on June of this year, but it doesn't appear that that's going to be the case.
No, Bobby.
Based upon our daughter's progress in school. And so that her 19th birthday is October 31st, 2026. Based upon what I can see in her student record, it doesn't appear there's any chance that she can finish her high school education prior to that. And she has refused a GED alternative and is not attending school. So I haven't been able to get any confirmation from Mia or the school about that situation and whether or not it's likely that she could graduate sooner than that. So my assumption is I'll be paying child support until the end of October, and November 1st would be the first month that I would not have child support. So that's the other reason that I think it would be helpful to be able to delay these payments until there's more certainty as to what my monthly obligations actually will be. With regards to the strength of the appeal, I guess I'd probably tell you what the nature of the appeal is. It's in the docketing statement that you might have read before this. I don't know if you did or not. There's 3 principal issues. One was whether or not there was a clear purge condition set for the contempt motion that was achievable for me at the time and later once the amount had been clarified. And I think my recollection of the proceedings was that I had expressed uncertainty about this for a long time, and that it wasn't until September that that number became certain when the child support agency confirmed that. So I know that we discussed that at court as well, and it's confusing to me to know who has the right number.
No, child support is when they turn 18 or they graduate school, whichever comes first. No, second. Whichever comes second. If they're still in high school at 18, if they skip a year, then you have to continue to pay child support while they're in high school.
So, meeting the conditions of the commissioner's orders on time with an unknown amount owed was one of the factors that led to the contempt. The other two issues were the inclusion of attorney's fees for failed settlement negotiation when that settlement negotiation was never brought as evidence to the court. And there was a statement in your order that said, unless I could show that those were unreasonable in some way, that they were an effort on the other party by the other party to reduce costs. And I do think that those were not reasonable, and would have appreciated a chance to talk about that, but I didn't know that that was actually admissible. And then the other issue would be the attorney's fees for clarifying and correcting the legal error about burden of proof, and whether or not those arise from contemptuous conduct, or whether or not that arises from the uncertainty of the court as to the burden of proof at the time. Those are
So what happened was, they're going through a divorce. He was hit with child support and spousal support, which he just never paid. This judge warned him, you have to pay. Instead of paying, he kept arguing. Wait, do I pay this? Do I pay this? How much do I pay? The judge told him how much to pay. But then he asked, I think he had a lawyer at the time, he asked his lawyer, he asked the child support office, and he got 3 different amounts. And the judge was like, I don't care what amounts you got from anybody. I told you what to pay. I gave you a number. You are in contempt of court. And because he wasn't paying, she had to get a lawyer to take him back in, to get him to pay. So she sued for attorney's fees and won, because he just refused to pay anything. So now he has his child support, spousal support arrears, and attorney's fees. And now he has the cases in appeal, which he had to spend money to file for, and she has to spend money to get a lawyer for. Guess what that means? She's going to get more attorney fees. But we'll see. Didn't happen yet.
The 3 substantive issues on whether or not, whether or not I was really willfully trying to defy the court order, or whether or not I was in a position that I didn't know how to comply with the court order, and secondly, whether or not some of those fees were actually appropriate to award.
Okay.
That's my 4 points.
And have you by chance reviewed what standard of review the Court of Appeals will be applying to any of those?
Yeah, well, my understanding is that it's not an evidentiary hearing, right? So it's not that I can re-argue the evidence of the case so much as to point out where I think perhaps the law did not support some of the judgment.
I guess that is what kind of the point I'm making is, you're right, it's not evidentiary. They don't take evidence, but they have one standard of review if you're challenging a fact finding, which is a pretty high one to overturn a finding of fact by a judge or jury. They have a different standard of review, de novo, if it's about the interpretation of law or...
Oh, Bren, I made the most delicious chicken and rice last night. It was so good. It cooked the whole time I had my stream, so the whole house smelled like it. I ate 2 plates. It was delicious.
Even often of the application of law to facts. And that means that I have to consider that they're considering it brand new. And then there can be mixed questions of fact or law, and there might be a range of standards or a standard in between the extreme of de novo, which is a brand new review by them, to a very deferential finding of fact, or there's certain decisions by a court where it's essentially an erroneous exercise of discretion standard where they only overturn if I essentially ignored a fact or law or just didn't apply the relevant law or didn't explain how I did. So had you looked into any of that about which one of those or if a mix of those standards apply?
I think there's a mix. And I'm feeling a little cheeky right now. I'm talking to the person who.
It's an absurd position to be in. It's also absurd for me because I have to sit here and say,
I know.
Is it erroneous? Well, no, I made the decision, so why would I think that? But I have to sit back and not think of my decision. I have to think of what are the chances the Court of Appeals will decide it differently or agree with me. Yeah. So don't be afraid. You're not going to insult me. I've been through these many times with many types of cases.
I'll insult you.
Well, originally you found no contempt, and then it was on you reversed that on the basis of this Van Offeren case, and which is sort of like one line that says the burden of proof on the contemptor is to prove that they were not in contempt. And on the, if it's just a black and white issue of whether or not I paid all of the arrears by February 1st, 2025. And obviously somebody would say that I didn't, right? I did not. Had I been making any attempts to pay it by then? Well, I did make one payment in November, and that was through income withholding, according to the CSA online records, and that was for $1,016 and some change. And that should be in the record and in the document 318, which is the clarification from the child support agency, Mr. Jeff W., showing the history of payments. And so at least there was some payment made before the deadline, and then I, of course, was trying to make good faith payments after the deadline. As you noted, it was after. So it's not exactly true, accurate when you said that the only payments I made were after the deadline, so therefore I was still in contempt by the deadline. I had made a payment through income garnishment prior to that, and that's understandably probably a nitpicky factual issue, and you weren't looking closely at the record, and I can see why. You might have missed that and why, I didn't raise it. Nevertheless, the standard of willful defiance of the court order, I just don't think applies in my case. I had asked for clarification of the number many, many times. I never got the same answer twice. We talked about it in court over a 2-day period. And
then when you talked about this number in court over a 2-day period, did the judge give you a number at the end? In writing? In the order? Sure did.
Mia and Attorney Bach Van Horn presented one number, and you came up with another number, and then I corrected that, and then we had asked for clarification from the child support agency. And so
I'm just wondering, did you get any of the Mexican food, or did I eat it all? Just wonder how realistic this was.
In the position of a pro se litigant who I am working with an attorney, but frankly, he wasn't getting that involved in the details of the case. I truly was trying my best to show good faith and not be in contempt while also attempting to figure out what the actual payments would be. So on that issue, I think that there's a legal standard that needed to apply on sort of my motivation and willful defiance versus, whether or not there was a clear purge condition established for me to follow. And
I make special brownies too, but they're not bacon.
So that's, I think, so there's some evidentiary, by the time I was held in contempt, which wasn't until December 11th, almost all of the arrears were paid, right? Like 4/5 of the arrears had been paid by that time, either through income withholding or through the direct payments. And so at that point, the arrearage was determined to be somewhere around $700 and some dollars, I think. And less than the $974 because another income garnishment had been paid. So it seemed that the $6,000 and whatever it is, $405 worth of attorney's fees is a high cost for an arrearage that was almost fully paid by that time and did not, I don't think, required all of the litigation that was conducted for that. So that's essentially the basis.
Attorney Bach-Van Horn, any argument?
Thank you, Your Honor. As Mr. Flieger mentioned, we did make a proposal, and I don't need to go into the specifics, but there was no response.
Me and Donna went to this restaurant once where we got this appetizer of bacon. It was delicious. It was real thick, and it was so good. Then dinner comes, and we got this little tray of salt. I think it was 3 separate piles of the different salts for our dinner. That I thought was really, really, really good. It was just delicious all around. The bartender made me a special drink. I don't know what it was called. I just told him I wanted something fruity and delicious, and he himself was fruity and delicious, and he got me a fruity and delicious drink. It was really good.
At all. This seems like something that should be an issue that can be resolved between the parties. This has been kind of the MO throughout this matter, throughout all of the matters that have occurred post-divorce. The amount we're talking about is $3,630. Just looking at Mr. Flieger's financial disclosure statement from January this year compared to February this year, documents 334 and 349, it looks like he's been able to pay off over $15,000 in credit card debt over the course of just over a month. But certainly the credit card debt is astounding. These parties divorced in 2018 with a clear equal division, and I don't know what he's spending his money on, but I do think that if a stay is granted, he needs to post a bond for what's owed. There seems to be excessive spending on something. I don't believe that this could all be attorney's fees when it was a limited scope representation situation. Perhaps unwise financial decisions. I don't know. We haven't done discovery to figure out what the spending is on, but I do think that in order to protect interests, there should be the money that is owed should be protected in case the appeal is not successful. As far as whether it would be successful, I think, Your Honor, I think you made well-reasoned decisions, and they are very clearly written out, and I think the record reflects that.
I support that very bad decision, Mel.
You exercised your discretion as was appropriate, but I can't make the determination on whether or not he'd be successful ultimately. What I do know is that I think if you are intending to stay, we need to protect the funds that are owed in case they remain owed at the end of the appeal process. Alternatively, Ms. Cox would agree just to start the payments for the contempt attorney's fees, to start those after the arrears have been paid off, which we believe will be beginning August 1st of this year. So that should lighten the burden for Mr. Flieger if the court finds that's appropriate.
Mr. Flieger, is that something you'd want to agree to, which would obviate the need for me to rule?
Does it foreclose my option to appeal?
No, it would waive your right to ask for a stay pending appeal. It would just change it so that you're only paying after the arrearage is gone. So then you don't have both the payment toward the arrearage and the attorney fee. If you prevailed on appeal, you'd still have all your rights, including, depending on what the Court of Appeals rules, to either have a rehearing or re-argument with me or a substituted judge, or to have an award returning funds to you that you'd already paid.
I mean, I would be agreeable to a payment delay in the payment plan for sure, and I do appreciate that the offer was sent, and And I just want to say that here, I did appreciate that. And I think it's important, however, there was communication back and forth. That I have not received any responses to that. I'm sure Mia or Ms. Bach Van Horn would argue is unrelated, but to me it's related, which is the status of my daughter's educational path and whether or not that will be completed at some point in the near future or in the distant future. And so I would.
So you've already said that based on what you saw and how you communicated with the school, there's no chance she's going to graduate this year. So you're asking Mom if she's going to graduate this year? You're waiting for a reply from Mom to see if she's going to graduate this year? Sir.
Agree to something where payments would, I think arrears should be done by August 1st. I can talk to the child support agency person this morning about that. He can't guarantee that it's at a zero mathematical number, he said, but it should be close by then. I am definitely in compliance with the order to pay the $150. So, but the way they account for that is really hard. It's hard to grasp by looking at the balances, and he wouldn't provide me anything in addition to that. However, by November 1st, for sure, the arrears should be over with. And at that point, I think we will be discussing the end of child support. And I'm sure there will be a corresponding request to increase maintenance by Ms. Cox at that time. But at least, we will have moved past the child support time period. And so if that was the date, that seems very, very reasonable. And if it needs to be bonded because somebody doesn't trust that I'll pay when I've always paid, even if it took longer than I had hoped.
You are currently in arrears and you were found guilty of contempt. What do you mean you always pay? What does that mean in your head? Because in my head, if someone says I always pay, that means they always pay. That's
fine. I mean, I don't know what that means, but I'm not going to not pay and just walk away or, run off or something like that and skip town. I have obligations here. The other thing that I didn't mention was the uncertainty of my position at the university, and I'll just, for one extra bit of detail, there are budget cuts and there is a 10 to 15% reduction in non-instructional staff. That's what I am. And of course, as we talked about in court, I'm at will. So I'm very nervous that, and in a time of unprecedented budget shortages and layoffs at the university in positions like mine, that could happen. And that could happen anytime, but probably between July 1st and the end of the year. So I'm trying very hard not to commit myself to, again, without knowing the details, to a payment schedule that I cannot meet and that will just result in me being in contempt again for lack of sufficient funds. I didn't pay off $15,000 in credit card debt. By the way, I negotiated a settlement for that. So by paying off about 40%, I will pay off 40% of that debt on 2 cards. So, and that's somebody in my situation has a right to and does often negotiate directly with the credit card company. So I didn't have $15,000 magically appear here. So something like a November 1st start date on repayment would be more in line with what I think is actually happening with regards to our daughter, who I can't verify and haven't been given any documentation by the other party, but I do think that that's a factor that I'm considering. Did that make sense?
It made sense, yes.
May I say something?
What's it going to be about, Ms. Cox?
Well, Michael said that I didn't cash the $200 check in February. I absolutely did.
Oh, okay.
Okay. I didn't see it in my online banking, so good.
All right. I'm going to rule on the motion for stay pending appeal. Applying the case law that I had talked about at a bit of length, mainly coming from the Scullion case earlier, I'm going to find that Mr. Flieger has not satisfied me that he's met the factors to show that I should grant a stay pending appeal. I do think there might be aspects of his claim where I would give him some credit that the Court of Appeals will apply a different standard, a non-deferential standard, to some of the application of law to fact, and that he might have a decent leg to stand on with the Court of Appeals on some of that. So that weighs in his favor. The other ones are more neutral, or against him. There's probably some factual findings that he would have a quite high burden on. But then the ones where your argument really falls short are the irreparable injury to you if I don't grant a stay. And this is one of the ones where the Scullion court talked at some length about. It's pretty hard with a money judgment. You'd have to really show me you're probably never going to get your money back, or you're going to have some really significant burden by having to pay it while the appeal is pending, knowing that it might get reversed. And here, for all the reasons you really just touched on yourself, I could find that it would be very easy to get you paid back. Mainly, the simplest solution would be reduce arrears you owe if they're still owed, or more likely reduce maintenance by the amount to pay you back. In other words, pay you back from your own money and your own obligations. And Ms. Cox would, in that circumstance, have no choice, meaning it's not contingent on her writing a check or you trying to collect against her to get paid back. It's a reduction of a benefit that you have to pay her. So I have quite good control over that, actually, to get you paid back. So that factor is very strongly against a stay. And on the other side, Ms. Cox could have some harm from not getting paid while appeal is pending. That could include, just because you're not helping to pay down some attorney fees doesn't mean she doesn't have to, and then that's money out of her pocket. I would have to potentially consider interest on that. And it's a little tricky because this isn't technically a money judgment. It's a contempt order for a fee amount. So it's not even as clear as the case law has when it's a money judgment and there's a set interest rate on judgments. I would probably have to apply the statutory interest rate that applies to judgments would be a fair way to do it. It's a pretty high interest rate right now, actually. I think it's over 7%. So that is one way to make sure her time value of money is compensated for not getting paid if it would have to be sometime down the road. But there is a harm to Ms. Cox, certainly, from that. And then the other issue, I agree, I don't think there's a harm to the public interest. If there is one, it's the minimal one in enforcing judgments, but that one doesn't make any sense to me, because if you would win on appeal, then the public interest would have been served by not having you pay, because it would have been an order that got overruled. So it's not really one that the public is involved in. I agree with you on that. So considering those factors, the strongest ones are, I think that there's some issues on appeal that you have not shown a substantial probability of success on. There are others where I think you have shown that it might be one where there was enough dust in the air and need for clarifications, and me having to consider a reconsideration and some legal questions that the Court of Appeals looks at brand new that help you out, but everything else really weighs against you. So when I combine that with the fact of what was just discussed as essentially a settlement offer of deferring payment toward the balance until other obligations.
Listen, guys, use subliminal messages for your kids with their people that, like, okay, always have Tammy Wynette divorce ready in your car. So if they get in your car to drive somewhere, it just plays, puts seeds in their head, little seeds.
Of years under my orders that aren't being appealed go away. That defers some of the financial burden on you as well, which eases the harm to you by enforcing it right now. And I am going to modify those. So for all those reasons, I'm denying the stay pending appeal. I'm granting your request to modify my order. I think it's a reasonable one that Attorney Bach Van Horn put out there that was apparently offered as a settlement to you of let you pay off the arrears first and then start making the payments toward this attorney fee amount. And that way you're not doubling up essentially of having, well, it's really tripling up, having support, which is maintenance and child support, plus payment toward arrears, plus payment toward attorney fees. I think we could get into, and I could ask questions and nitpick some of your financial disclosure. And there's some arguments that could be made about what amount to count toward monthly payments on credit.
That would be lovely, Brent. That would be lovely. I have rage. I would love I'm Irish. I would love a nice fight. That would just make me happy, I think.
Credit cards and all of that. And we've ran out of time, so I don't have time to do that. But if I felt it was really important, I would give you more time. But I just think this is so reasonable for the reasons you pointed out and Attorney Bach-Van Horn pointed out, of if we just defer it until the arrears are paid off, the financial picture is going to change pretty substantially. It sounds like you're actually also paying toward those credit cards that are going to negotiate with you in a pretty heavy amount right now. So by the time we get down
You know, if you mix them all in one cup, you can have a whole buffet.
there, those big payments perhaps will be gone or nearing being gone. So your financial circumstances will be a whole different picture. And the things you pointed out of, at the very least, the longest you will pay child support is your daughter's next birthday. It could be even sooner that obligation disappears. So that's going to be my order, is the payments toward the attorney fees will not start until your arrears are paid. And I'm going to say it's until the month following your final $150 payment. In other words, if you only have to pay 30 or 40 bucks to finish up, then you should start paying toward the attorney fees that same month that you pay a very small amount toward the arrearage. So it'll just trigger whenever that is. And I won't know when that is. Hopefully one of you will know it, and you'll talk to each other and just submit a stipulated order saying, this is the month where we're starting. And if not, you'll tell me, hey, Judge,
Well, Eileen, the two other children during our marriage didn't help much. didn't help the marriage.
realize now that this is the month, this will be my final payment toward arrears. So please update the record to say my attorney fee contribution payment for the purge starts whatever it's going to be, August, September, October. I'm not deferring it until that November date because
Dr.
that's
Seuss
tied
is
more
well
to
written.
uncertainty about your daughter and when that'll end. And I'm tying it more to the arrears. I'm tying it directly to the arrears payment. Any questions on that order modifying or my denial of your motion for stay pending appeal?
I have one question, just on implementation, which
Yeah, but it's a ditty. It's a ditty, Eileen. And all you keep hearing in your head is DIVORCE. It's just a little C.
would be, other than agreeing with Ms. Cox on the date of a stipulated, the enforcement of a stipulated agreement, say that's August 1st or September 1st, is there any documentation that the court will require to verify that those arrears are actually paid off? Like a statement from the agency or something?
Not unless there's a dispute. So if I really am saying, if you all agree, because it should be clear from the child support records when this is done, just put into the record we agree that it's paid off as of this month and therefore the attorney fee contribution.
It took me a while to get to that point, T. Listen, there's a lot of authors I cannot stand. And, morally outraged, I feel like, I separate their work from them. I just have to, because there are some great books out there that are still great, even though the author is such a jerk. So I separate, in my head, I separate that person from this book. I had to, because I would miss out on so many good books if I had to just find books where the author was normal.
Starts, and that way it's indisputable if it ever comes up that this was the month when my order went into effect. If there's a dispute about exactly when the arrears get paid off, or you just can't agree, or you don't talk and nobody brings it up, and then down the road this becomes a problem, somebody's going to have to recreate and prove to me when the arrears wrapped up and the attorney fee should have started, because it will be an indisputable date once the arrears are paid in full. When they're paid in full, they're paid in full. So it shouldn't be hard to prove after the fact. I'm just suggesting to reach an agreement, put it in the record, and that way we all have it in the court record of this is the day. So it's very simple and we don't have to try to recreate it. If nobody does that, then it's just a recreation thing at some.
And I also don't listen to opinions on a book from people who've never picked the book up, because that's stupid.
Later date, if it ever matters. Attorney Bach Van Horn, anything for you? Any questions on those things?
I don't believe so, Your Honor. I feel it was very clear. Thank you.
Okay. And Attorney Bach Van Horn, I don't know if you've had any discussions or thoughts about the schooling situation. It was a little unclear to me from Mr. Flieger where he thinks it stands, but he probably doesn't have great information.
So it's been some time since I discussed with my client, but I know that she's been having trouble getting the information that they're both wanting from the school. And once she has it, she will provide it. That's my understanding last we spoke on the topic.
Okay.
I'd just like to ask what the difficulty is. Mia has access to the records and the school. I've been boxed out so I'm not allowed to speak with the school at this point, but Mia does, right?
So I don't have an answer to that, Your Honor.
Yeah, I'm curious myself. Ms. Cox, is it because your daughter's 18 that they don't really talk to you, or what's going on with that?
I'd be happy to address that. Yes, it is because she is 18. We originally had a document in the beginning of the year saying that she would graduate in June if she did everything correctly. Like went to school, didn't miss anything, took all of her exams. She actually has been extremely depressed and has not gone to school since October. She recently finished ketamine infusion, so that took her out for a complete month with the treatments. I am still waiting. I have an appointment Thursday with her IEP person, and we need to keep her enrolled in case she is healthy enough to go back to school. But until I have that meeting, I will not be able to get an updated document that states that she will not pass.
Oh. Okay. Well, let me just, so we're all on the same page, and Attorney Bach Van Horn can talk to Ms. Cox more about this, and Mr. Flieger can review it at his leisure. 767.511 sub 4. The court shall order either party or both to pay for the support of any child of the parties who is less than 18 years old, or any child of the parties who is less than 19 years old, if the child is pursuing an accredited course of instruction leading to the acquisition of a high school diploma or its equivalent. I think there's probably room for interpretation there of...
Yeah, because if she's not going to school at all, then is she pursuing her diploma?
What it means to be pursuing an accredited course. I don't know if simply being enrolled but not attending any school counts. I've never had to address that. And I don't know if there's case law on it. But it sounds like, and I'm just putting this out there because things have been very litigated in your case, and I'm fine with that, and I will hold hearings and I will decide things. But I think we've also had a lot of discussion about the less of that each of you have to deal with, the better for both of your sakes and your daughter's sake. If it becomes pretty clear that there's not really a leg to stand on, that she's actually pursuing an accredited course of education that'll lead to a diploma, the statute says it would need to end when she turned 18 or stopped pursuing that. And part of the reason for that is 18-year-olds make their own choice. So if they choose not to go to school, you have literally no authority to make them go to school. They are an adult, so they can choose not to finish school and not to get a diploma. And if they make that choice, then there's no child support obligation owed. So Mr. Flieger would have a right to know all of the facts that Ms. Cox is aware of about whether or not your daughter is actually going to school, which would include your own observations, Ms. Cox, of is she actually in school or not, and what plans are there to pursue that course. So if there was discovery and if it came to me, it seems to me there's a pretty clear-cut right to get whatever info you have through interrogatories or other means. You probably, it sounds like, won't have actual access to school records, or that either one of you would have to subpoena the school to try to get them, and they might fight that, I'm not sure. So we're not going to get into that further today, but I thought it was worth asking a little bit while we're all here so that you can all, Mr. Flieger probably wouldn't hear it otherwise, and I know settlement isn't always productive between the two of you. So at least we all got to hear a little bit about that, and you should further talk, Mr. Flieger, if you want to try to resolve that, or maybe ask me or file another motion so that we can, I guess, have a hearing on if there really is any pursuit of a degree happening here.
She is wanting to, if she can't get a traditional education, which actually probably is not the case, she would still like to be able to go to school if she's feeling well enough, but she does want to get her GED. That is definitely something that she wants to do.
That's great, and I hope she does. But again, wants and pursuing are two different things.
True.
Yeah.
Yeah, we do just, I know that we're not having a new hearing on this issue. We could. I still have, and I'm sure Mia still has access to Infinite Campus, which is the electronic.
Jimmy Jones was the leader of a cult. Was it the 80s or 70s, guys? In the 70s or 80s. I think it was the 70s, which probably means it was the 80s. And he took a whole hundreds of his cult followers to this island, and he made them a special Kool-Aid drink, which is, what was it, grape? I don't know. It was grape or cherry or a sugary grape or cherry drink. And he poisoned it all, and then he forced everybody in the cult to drink the Kool-Aid. And a whole bunch of them died. A large amount of them died. And people who didn't drink the Kool-Aid were shot trying to escape. He had people with AKs or whatever around the perimeter to shoot anybody who tried to escape, like mothers with their children trying to escape. Wasn't there my brain, wasn't there like a congressman or a senator or someone like that who got shot and was able to make it to a plane? Oh, they didn't make it to a plane. Thank you, Donald. Yeah, they shot a congressman trying to not drink the Kool-Aid and live. So when someone says that you're drinking the Kool-Aid, they just mean that you have ideas that you have them believe in so much that they're willing to drink Kool-Aid and die for your ideas.
School records, so I can see attendance and grades and so forth, and absences, and the absences have been excused weeks or months in advance in some cases. I don't know who is excusing those absences, if it's Mia or Lily gets to excuse herself.
That's right, Jim
but that's
Jones.
what the record
You're
reflects.
right,
The
you're
school
right.
has been tight-lipped about it for the obvious reasons that they probably do not want to get embroiled in a lawsuit between Mia and me or something like that. And so I'll just let you know that is really helpful to hear from you today, because this has been weighing on my mind for a long time now.
Well, she did have a doctor's note for the entire month of February while she was doing her treatment. So that's why that month was excused.
I'd love to see it.
Okay. All right. And I'll say, I don't think we have a pending motion open because I'm sure my rulings from that trial resolved everything. So in my mind, unless and until someone files something, it's not an open question right now, but you brought it up. So it's worth getting a little bit of info so you can hear that today in a less contentious way for all of you. So with that, I'm going to let you all go for today and get on to my next hearing. I'm going to draft a very short order, essentially saying for the reasons stated on the record that I denied one motion, that I granted the other, and the little bit about when that attorney fee payment's going to start. So I should get that uploaded for you today still, probably.
Okay. Thank you.
Your Honor.
Thank you.
Yeah, you're very welcome. Have a good day, everyone.
You too. Bye.
Oof. All right, guys, we made it to the end. We did it. 3 live streams in a row, it feels like. Back to back. I appreciate you all coming out. Thank you so much. Remember, next Wednesday, there's not going to be a live stream in the evening. So, because I have to work. So, but I shall see you all tomorrow morning. It's Thursday right now, so I will see you Friday morning. Behave. Get your Easter baskets ready. And if you make Easter baskets, put pictures in chat so we can all see them. Enjoy your buffet, Bren. Bye, guys. Thank you.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace, come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time.